You destroyed our homes. That's what she screamed, standing on my land, pointing at a house that didn't even lose a single shingle. I thought it was a joke at first. Then came the lawyer, then the envelope, then the $15 million demand. All because my grandfather built this place to survive, and theirs didn't. Now they're saying I caused the hurricane. I don't live in their HOA. I'm not even in their zip code. But that didn't stop them from sending threats, filing claims, and trying to ruin my life with lies and faked science. Comment what you would have done if they came after your home, too. Morning after the hurricane, I stood on my porch with coffee cooling in my hand. My property sits on a slight rise, just beyond the reach of the Pine Ridge HOA development. I looked northeast toward the subdivision. Even from here, I could see devastation. Roofs gone, walls collapsed, blue tarps already going up on a few houses. Debris scattered across yards like someone shook a snow globe full of broken furniture. My house, completely intact. Grandfather's raised foundation design. Sabal palms he planted in '62 acting as windbreak. Hurricane shutters held. Not even a loose shingle. 60 years of engineering versus 20 years of profit margins. The difference was visible from 300 meters away. I walked my property line. Wind ripples and sand along the fence showed a clear pattern, southwest to northeast. Parallel lines, undisturbed except for deer tracks. I pulled out my phone and recorded video, panning the entire property. Then I took still photos of the sand patterns. My property faces the direction wind came from. The HOA development is downwind from me. Basic geography, the kind you learn in elementary school. Wind does not change direction because it passes over a house that was built properly. Mid-morning, a vehicle pulled up my long driveway. A woman in business attire got out. A man in a suit followed. I stayed on the porch. She approached with quick, confident steps. Mason King, I am Lydia Navarro, president of Pine Ridge HOA. I did not move from the steps. I am not in your HOA. We are aware, but your property's position relative to our community is relevant. May we speak inside? We can talk here. I was not letting them in my house. She glanced at the suited man. This is our attorney. We are here to inform you that preliminary engineering analysis suggests your property's structural features may have contributed to wind deflection patterns that impacted our community. I stared at her. You are blaming my house for your damage? We are informing you that we will be pursuing a civil claim for damages. Your property sits directly upwind of Pine Ridge. The contrast in structural outcomes is significant. I almost laughed. Almost. My house was built right. That is why it is standing. The attorney spoke. Mr. King, we are filing a $15 million recovery claim with federal disaster programs. If structural causation from adjacent properties is proven, those funds become accessible. We are offering you the opportunity to cooperate voluntarily. Or what? Or we proceed with compulsory legal action. He handed me a thick envelope. You are being served. They left, just like that, dropped a lawsuit on my porch and drove away. I did not open the envelope immediately. I called a mobile notary. She arrived, opened her logbook on my porch table. Document that needs sealing? I handed her the unopened envelope. Legal demand. I want a timestamp before I read it. She examined it. You have not opened this? That is why you are here. She sealed it, wrote the timestamp, handed me a receipt. Smart move. People do not usually think of this until after. But I had seen enough disputes in my years as a building inspector. Documentation matters. Timestamps matter. After she left, I opened the envelope. I read the civil complaint. Defendant Mason King's property, through structural configuration and wind deflection, materially contributed to catastrophic damage at Pine Ridge HOA. Plaintiff seeks $15 million in damages. I sat down. They were actually doing this. They were suing me for building a house that did not fall down, for having a grandfather who knew what he was doing, for being on property that was not even part of their neighborhood. That evening, my property mailbox, perched beyond HOA boundaries, had paper taped to it. You destroyed our homes. You will pay. Written in marker, no signature. I photographed it, added it to the folder I was already building in my mind. This was not going away. They were coming for me. 2 days after being served, I got a text from an unknown number. Pine Ridge HOA community meeting tonight 7 p.m. Your name will be discussed. Thought you should know. A concerned resident. I debated going. I was not a member, but they were suing me for $15 million. I should hear what they were saying, what lies they were telling about me, what narrative they were building. I arrived at the Pine Ridge Community Center, building inside their development, parking lot full. I walked in. 30 residents. They turned, stared. I was the only outsider here, the only one who did not belong. Lydia at the podium saw me, paused mid-sentence. Mr. King, you are not a member of this HOA. You are suing me for $15 million. I think I have the right to hear your accusations. Whispers rippled through the room, people shifting in seats. Lydia spoke carefully. Very well, you may observe, no speaking, like I was a child being allowed to sit at the adult table. First slide appeared. Wine damage analysis, recovery funding pathway. Lydia read from notes. Under Federal Disaster Recovery Program, we can access $15 million if we prove man-made exertion of damage. She stumbled over the word. Exacerbation. She meant exacerbation. She clicked to an aerial view. Circle highlighting my property in red. Pine Ridge Development in blue. Arrow showing wind direction. The King property sits directly upwind. When we planned this assessment before the storm, she stopped. I mean, when we assessed damage after the storm, the engineering showed clear deflection patterns. I was recording audio on my phone under the table, before the storm. She said before. A resident raised her hand. But his house is not even in our neighborhood. How can we sue him? Lydia responded smoothly. Civil tort law allows claims against any party whose property caused damage, regardless of HOA membership. The $15 million recovery fund is specifically for man-made causation cases. Another resident leaned forward. So, we get $15 million if we prove he caused it? The HOA accesses those funds, yes. All repairs would be covered, plus legal costs. I thought about that phrase again. When we planned this assessment before the storm, they knew this was coming. They were ready. I raised my hand. I would like to see the engineering credentials. Lydia looked at me coldly. This is a members-only meeting, Mr. King. You are discussing a lawsuit against me in a public meeting. Security, please escort Mr. King out. 2 residents stood. Big guys. Probably thought they looked intimidating. Come on, buddy. You heard her. I stood. I have this whole meeting recorded, including your slip-up about before the storm. I walked out before they touched me. Let them wonder what I had. Let them worry. A woman approached me in the parking lot. Mid-40s, professional clothes, moved quickly, like she did not want to be seen. I am Rebecca Shaw. I live in Pine Ridge. I voted against this lawsuit. Why? Because it is insane. Your house survived because it is well built. Ours collapsed because the developer cut corners. Everyone knows it. But Lydia is convinced the board that blaming you is easier than suing the developer. Why are you telling me? She looked around nervously. Because this is wrong, and because I am treasurer. I see the finances. Something does not add up. She handed me her card, walked back inside quickly. Next morning, I called the county clerk. I need to submit a public records request under Sunshine Law for Pine Ridge HOA. You a member? No, but they are suing me. Their board communications are public record in this state. That is correct. Submit in writing. I emailed the request. All board communications, vendor contracts, and meeting minutes related to wind damage assessment and litigation funding. 3 months prior to the hurricane through present, 3 months before. If they planned this, there would be evidence. Afternoon, I drove to the hardware store in town. 3 Pine Ridge residents in the parking lot saw me. There he is. The guy who destroyed our houses. One pulled out a phone, started filming. Everyone see this? Mason King, living in his mansion while we are homeless. Mansion. My grandfather's simple raised house was now a mansion. I ignored them, went inside. The manager approached. Sir, I am going to have to ask you to leave. You are causing a disturbance. I am not doing anything. Please leave, or I will call the police. I left. They followed me to my truck, filming, shouting. I did not respond. I just drove away. That night, I was reviewing my audio recording from the meeting, clear as day, when we planned this assessment before the storm. Knock on the door. I looked through the window. No one there. I opened the door carefully, USB drive on the doormat. Small note, this is not right. A concerned board member. Someone inside was breaking ranks. I plugged the USB into my laptop. 3 folders, invoices, emails, contracts. I opened invoices. A file made my stomach twist. Cortex sampling equipment, .pdf. Dated 2 days pre-hurricane, 12 core tubes, 24 wind stakes, 100 site flags, all shipped to the Pine Ridge HOA office. They ordered storm tracking tools days before the hurricane even hit. I opened the emails folder. Thread between Lydia and j.navarro@coastalclaims.com. Subject, King Property Funding Application. 5 days before the hurricane. L asked, how solid is the causation theory? J replied, perfect optics. His house stands, ours collapses. That's ideal framing for 15 million funding. L asked about timing. J answered, must set up before landfall. Story won't stick if built later. I read it again. They plotted this before the storm even hit. I didn't just save the files, I burned 3 DVDs. 1 locked in a bank box, 1 in my home safe. 1 needed official custody. I called the city inspector who documented my sand patterns. Can you log evidence under chain of custody? If for legal use, yes. I drove to the city office. He signed the receipt with timestamp. Good thinking, he said. This locks in authenticity. 3 days later, a glossy newsletter appeared across neighborhood mailboxes, not just Pine Ridge. Front page headline, Understanding Our Recovery, the Adjacent Property Factor. Lydia's article didn't name me, but claimed the land southwest of Pine Ridge had disruptive energy flow. She even quoted a local feng shui consultant who said the elevation imbalance deflected destructive chi into the subdivision. They pushed this bizarre theory across the neighborhood, turning me into a bad omen in a superstition they invented post-storm. My real neighbor, half a mile off on rural land, dropped in. Mason, this HOA flyer landed in my mailbox. They're talking about you, right? Yeah, it's pure nonsense. Your home's weathered 6 decades. Theirs is still wet behind the ears. Try telling them. Want me to write a letter? Really? Of course. Your granddad built right. Everyone out here knows it. He shook his head and left. Unreal. 5 days later, the city parks department sent heritage tree records. My Sabal palm grove was listed. Heritage planting, documented 1962, with county-level protection status. I also pulled building permits and inspections for my lot. 1962 through now. Every inspection passed. Shutters rated for Category 5. Foundation certified by a licensed engineer. Meanwhile, I pulled Pine Ridge records. Multiple violations during build. 3 stop orders, 2 variances to allow cheaper materials. Stark contrast. Evening arrived. An older man pulled up. I knew him from the meeting. Mr. King, I'm Carver. I live in Pine Ridge, been there since before it was called that. Since the 70s, back when it was farmland. How can I help? He seemed uneasy. Lydia came by today. She knows I have old area photos, including yours. She pressured me to stay silent, claimed I'd face legal costs if I back false claims. She threatened you? Kind of. Yeah. He handed me an envelope. So, I came now, before I back out. Inside was a stack of photos. One showed my house, 1975, under construction. Grandfather visible in the shot. Another showed the area where Pine Ridge is now, dated 1980. Empty farmland, slight downward slope, drainage issues visible. The most important one was recent. Dated the day before the hurricane, it showed a Pine Ridge construction crew working on row B houses. They were removing hurricane panel connectors. Carver spoke quietly. I documented it because it looked odd. I handed the photo back. Thanks, I'll follow up. But 2 days later, that exact image appeared, cropped and distorted, in the HOA's counterclaim exhibit. They claimed I forged it. Carver never answered my calls again. I realized I'd been played. That night, a call from an unknown number. Male voice. Mr. King, this is attorney James Hendrick representing Pine Ridge HOA. Your continued contact with our residents constitutes harassment and tortious interference. Cease all communication, or we will seek a restraining order. I have not contacted anyone. They contacted me. That is not how our clients see it. This is your only warning. Click. I sat in the dark, looking at the photo of the removed connectors. They were getting desperate. I head straight to Pine Ridge with my camera in hand. I park on the far edge of the public road, step carefully onto the open sidewalk. Row B homes show by far the worst destruction. Collapsed walls, shattered structures, piles of debris scattered like matchsticks. I take detailed shots of every joint where hurricane panels are supposed to latch in place. The brackets appear unmarked. No scrapes, no torn or bent screws, only smooth, unused metal. If storms had torn panels off, there would be physical scars. Instead, they look unused. The panels were plainly never affixed prior to the storm's arrival. A resident walked up, smiling too wide. "Hey there, Mr. King. Out for a walk?" Another joined, voice smooth. "Hope you're not looking for trouble. We'd hate for anyone to misinterpret a camera around construction zones." Their friendliness felt thinner than the plywood on their walls. Within seconds, more people begin to gather, their tone growing hostile. I keep filming steadily, then retreat quietly before it escalates further. But I already had what I came for. Clear, indisputable evidence that the protective equipment had not been installed when it mattered most. I called the city building inspector the moment I got home. "Can you officially document those connection points?" I asked. He met me there the following morning. He examined the brackets on Row B homes meticulously. "These are clearly designed for hurricane panel connectors," he noted, "but there's absolutely no stress damage on the brackets themselves. That's highly unusual." He explained that if high winds had ripped panels off, we would expect torn, twisted metal. He took high-resolution photos, filed a full official report. "I'm flagging this," he said. "Something doesn't add up in the damage pattern." His documentation would carry serious weight in any investigation. I took the CFD slide from Lydia's presentation straight to a reputable print shop in town. The owner, who held a forensic certification, examined it under specialized UV light. "See these?" he pointed. "Tiny yellow dots, printer microdots. Most commercial printers embed them for tracking," I asked. "Can you identify which machine printed this?" He nodded. "With access to the right forensic database, yes." He photographed the dots using high magnification. "This pattern strongly matches the Epson SureColor series," he said. "Give me a few days to narrow the serial number range." A week later, he called. "Found it. Serial batch starts with J72. That's a specific manufacturing window." Back on my property, I documented the wind direction evidence with deliberate care. I placed a compass next to the large oak in the yard. The needle pointed due north. A deep vertical scratch scarred the trunk, running from 7 feet high down to 3, facing the northeast direction. Tree sap had dried in thin rivulets along the bark. I measured the marks, took photographs, and wrote everything down in detail. The data showed clear signs. The wind came from the southwest and bent the tree northeast. The bark was scraped where heavy branches thrashed against the trunk. I found similar evidence on 3 other trees. All showed identical northeast-facing impact. Nature doesn't fabricate. I emailed a well-regarded university professor in fluid mechanics and attached Lydia's CFD slide. "Would you be willing to review this and provide your professional opinion?" I asked. 3 days later, a detailed analytical response landed in my inbox. "This diagram shows axis inversion. The wind vectors are reversed. Pressure values are displayed using incorrect units. The color gradient doesn't follow any standard CFD convention." He concluded, "This appears to be a modified template, not an original simulation." I replied, "Can you provide a sworn statement if needed?" His answer came back within a few hours. "Yes." Happily, I studied the Polaroid from Carver with greater care. It showed a construction crew actively removing panel connectors the day before the hurricane. I could clearly read the company name printed on their shirts, Summit Property Services. I did some digging. Summit was the Pine Ridge developer's in-house maintenance company. I later cross-referenced this with the Sunshine Law records when they arrived. Sure enough, the HOA had paid Summit for hurricane preparation just 1 day prior to landfall. That preparation? It was the removal of protective panels. They had literally paid a contractor to make their homes more vulnerable. A certified letter landed in my mailbox. Amended civil complaint, Pine Ridge HOA versus Mason King. The plaintiff now increased the damages claim from $15 million to $20 million, tacking on punitive damages for what they called willful and wanton disregard for community safety through grossly negligent property maintenance. I read the document again. 20 million. They were doubling down, hard. Every escalation only fueled my case with more proof of their desperation. I placed the letter into my ever-expanding evidence file. Let them keep digging. They were getting desperate. Rebecca texted me. Can we meet? Somewhere off HOA property. I have some information. We met at a coffee shop in the neighboring town. She looked deeply stressed. Mason, I am the one who sent you that USB. I nodded slowly. Why tell me now? Because Lydia is getting desperate. She called an emergency board meeting last night. Increased your damages demand to 20 million. Hired a second expert. I was the only vote against. 4-1. Why help me? She stared at her coffee. 3 years ago, the HOA tried to fine us into foreclosure over a minor fence height dispute. We were right, but it cost $20,000 in legal fees to prove it. I know what it is like when they target you. Rebecca opened up her laptop. The browser showed a cached version of the web page, Coastal Claims Recovery website. This page has been deleted, but Internet Archive has a snapshot. She played me a news clip. Lydia, standing at a press podium, said, "We began preparing documentation weeks before landfall," then quickly corrected herself. Weeks before. That slip aired live. No edits. I didn't need screenshots. The evidence broadcast itself. Rebecca opened a spreadsheet. I have been HOA treasurer for 2 years. Look at these payments, she pointed. Coastal Claims Recovery. Initial legal retainer, $25,000. Dated just 2 weeks before the hurricane. Contract terms here. Success fee 25% of recovered funds. If they get 15 million, Coastal Claims gets 3.75 million. Exactly. And look who owns Coastal Claims. She pulled up a business registration. James Navarro, Lydia's brother-in-law by marriage, owns 30%. Family business. I stared at the numbers. What happened at the emergency meeting? Rebecca sighed. Lydia proposed increasing your damages to 20 million. Said the original 15 million was not enough to cover full community impact. She claimed you are being deliberately obstructive, and we need leverage. Who voted for it? 4. Yes, me, no. 2 board members were absent. It passed. She leaned forward. Mason, there is more. Lydia is hiring Dr. Richard Morrison as a second expert. I looked him up. He has testified in 11 similar cases. Always for HOA or insurance companies. Never for homeowners. Professional witness. Exactly. One more thing, Rebecca said. My husband kept an extremely detailed storm log that night. He is a licensed ham radio operator, Storm Spotter Network. What did it show? Wind consistently southwest to northeast. Sustained 55 knots, gusts to 72. He logged it every 15 minutes, submitted to National Weather Service. It is official record. Would he testify? Absolutely. He is furious about this lawsuit. Says the meteorology does not support their claim at all. Rebecca reached across the table briefly. I am sorry I did not speak up sooner. I looked her in the eyes. You are speaking now. That is what truly matters. She nodded. What will you do? I thought about grandfather, 60 years ago, building this house with his own hands, doing it right even when it was harder. Fight, all the way. That afternoon, the county clerk called. Your sunshine request is ready. 73 pages. I picked it up. Included all emails between Lydia and James Navarro. Invoice for core sample equipment. Printer ink purchase. Epson, delivered to Lydia's home address. Meeting minutes showing no conflict disclosure. Contract with Coastal Claims. 25% success fee. Everything I needed. 2 days later, a certified letter arrived. Notice of mandatory mediation. State law requires mediation before arbitration. Session scheduled 14 days from date of this notice. Attendance compulsory. 14 days to prepare everything. I spread the evidence across my kitchen table. Photos, invoices, emails, expert statements, tree bark markings, compass readings, sand patterns. The truth laid out in paper and pixels. They wanted a fight. They were going to get one. They were going to get one. Small conference room, state mediation center. Neutral mediator, both lawyers, Lydia and me. The mediator spoke first. This is confidential mediation to explore settlement before arbitration. Miss Navarro, please explain the HOA position. Lydia sat straight. Pine Ridge HOA has suffered catastrophic damage. Our internal engineering analysis strongly suggests Mr. King's property, with its elevated position and dense vegetation windbreak, redirected wind impact into our community boundaries. We are pursuing disaster recovery funding that becomes accessible upon presenting documented third-party causation. Mr. King's claimed liability mirrors the full scope of damage across the community. The mediator turned to me. Mr. King, they are committing fraud. I do not live in their HOA. My house is 300 meters away on separate property. It survived because my grandfather built it right 60 years ago. Their houses collapsed because their developer cut corners. They want to blame me to unlock $15 million so her brother-in-law's company can pocket almost $4 million in fees. The HOA lawyer stood. We now bring additional expert testimony. Dr. Richard Morrison, an experienced wind engineering consultant. A man in an expensive suit stood. I have conducted independent analysis. The King property's topographic position and vegetation density created measurable wind acceleration into the Pine Ridge development. My lawyer slid a file across the table. Dr. Morrison, records show you have testified in 11 causation cases in the past 3 years. All 11 for defendants, never for property owners. In 3 cases, your methodology was challenged. How do you respond? Morrison's face reddened. My analysis follows standard engineering principles. My lawyer pressed further. What's your compensation setup for this case? Long pause. $50,000 retainer plus 15% of any recovered damages. The mediator made a note. That changes the weight of expert testimony considerably. The mediator flipped through the documents slowly. Miss Navarro, about the original CFD report. Please state the engineering firm's name and the licensed engineer's stamp number. Lydia looked at her lawyer. He whispered, the report was prepared by a consulting vendor based on modeling software. That is not what I asked. Engineering firm name? Silence. Miss Navarro, you are asking Mr. King to pay $20 million based on a report you cannot authenticate? The vendor contracted the analysis. We do not have direct engineer contact. So, there is no licensed professional engineer who prepared this? The analysis is valid regardless of... That is not how engineering testimony works. The mediator's tone shifted. Miss Navarro, Coastal Claims Recovery stands to earn 25% of recovered funds. Your brother-in-law owns 30% of the recovery firm. Was this disclosed before filing the lawsuit? It is a business relationship. Disclosed to whom? To the board. Was it disclosed to county court when you filed civil complaint against a non-member property owner? Silence. Florida law requires disclosure of conflicts in civil complaints involving financial gain. Did you disclose? My lawyer spoke. The civil complaint filing has no conflict disclosure anywhere. The mediator called a break. The HOA lawyer approached me in the hallway. Mr. King, let us be realistic. You will spend $100,000 fighting this even if you win. We will settle. You pay $50,000, sign an NDA, we drop everything. Number. $50,000 is only a small fraction of $20 million. Plus, no legal fees apply. You can afford to settle this quietly. I am not paying for fraud. And I am not signing an NDA that stops me from exposing this. You are making a mistake. I have made my decision. The mediator reconvened. Miss Navarro, I cannot proceed without basic documentation. You have 5 business days to supply certified engineer identity and professional seal number for the CFD report, written conflict disclosure filed with court, and authentication of wind analysis methodology. Mediation is suspended until you comply. Lydia stood abruptly. This is procedural abuse. This is due process. 5 days. Outside, the HOA lawyer caught me at my truck. Mr. King, you are going to arbitration? You know what that means? Binding decision. No appeal. You lose, you pay. We are not backing down. $20 million is a lot of money, and we have Dr. Morrison. He got in his vehicle, drove away. I stood in the empty parking lot, 5 days until they either produced credentials or we went to binding arbitration. Arbitration. Larger room, formal setting, retired judge presiding, court reporter typing nonstop, county observer seated. This was final. No appeal, no backing out. HOA lawyer stood. Your Honor, we seek a ruling that defendant's property caused wind deflection damage enabling federal recovery. Document gaps stem from third-party vendor error. Lydia testified. We acted in good faith. Paperwork errors are on the consultant. Arbitrator looked at her. You signed the complaint. You're responsible for accuracy. My lawyer stood. Your Honor, 6 categories of evidence. First, geography, aerial photos, county surveyor, King property, elevation 240 feet, Pine Ridge 220, 20-foot slope across 1/3 of a kilometer. Drainage, not wind deflection. Second, the physical evidence includes scarring on the oak trunks, compass readings that remain consistent throughout the property, and wind trails still visible in the sand. A ham radio log captured wind conditions every 15 minutes, recording sustained speeds of 55 knots with gusts up to 72, all pointing in the same direction, fully verified and stamped by the National Weather Service. Third, in terms of construction, my property has documented permits dating back to 1962. Every inspection was passed, and the house is equipped with Category 5 rated shutters. Meanwhile, Pine Ridge shows a troubling record. 15 building code violations, 3 stop work orders, and multiple variances approved for substandard materials. Fourth, the issue of removed storm protection is confirmed. A Polaroid photo clearly shows a construction crew detaching panels just before the storm. The city inspector found no damage to the brackets, no stress, no torn metal, confirming that the connectors were never installed. An invoice shows Summit Property Services was paid by the HOA, and the official work order explicitly instructed them to remove the panels. When asked directly, the arbitrator leaned forward and said, "They removed protection before the storm?" The answer was yes. Fifth, the CFD report presented by the HOA was proven fraudulent. A forensic print expert identified Epson microdot patterns linking the document to cartridges delivered directly to Lydia's home. A university professor reviewed the file and confirmed that it featured inverted wind axes, incorrect pressure units, and visual elements consistent with a modified template, not a genuine simulation. When pressed, Lydia admitted there was no licensed engineer or authentic stamp involved. Emails recovered under Sunshine Law revealed plans to build this narrative before the hurricane even struck, and a website snapshot showed the case listed as in progress days before landfall. As my lawyer put it, they planned this. They removed protection, printed fake data, and hid their financial interests. At that point, the arbitrator delivered a final ruling. The evidence overwhelmingly showed bad faith. First, the defendant resides outside the HOA on properly engineered land. Second, physical data disproves the alleged causation. Third, storm protection was knowingly removed. Fourth, the CFD was fabricated. Fifth, premeditation is clear. Sixth, the financial motive was deliberately concealed. Therefore, the case is dismissed with prejudice. All legal costs are to be paid by the HOA and Lydia Navarro. The matter is referred to state prosecutors for potential fraud charges and to building authorities for negligence. The HOA is ordered to issue a full retraction within 48 hours. Lydia is barred from serving on any HOA board for 10 years. Arbitration concluded. And maybe that's what stayed with me most, how a house can outlast lies just by being honest in how it was built. I didn't shout, I didn't scheme. I just showed them the tree bark, the compass, the scars no one could fake. Maybe the real lesson here is, storms don't destroy everything, just the things not meant to last. If you're still here, I'd love to know what part hit you hardest, or if you've ever stood your ground like this. Drop a comment, hit like, or tap the thanks button if this story earned it. Stick around, we're only getting sharper from here.